Good afternoon, colleagues. I hope you are all well. I find you well and in good health. My name is Rangarirai, Machemedze, quite a sentence of the name, but you can just call me Ranga. I'm with the Southern and Eastern African Trade Information and Negotiations Institute, SEATINI, and I'm based in Harare, Zimbabwe. So I will be moderating this session, which has got three eminent speakers. And the session that we are focusing on this afternoon is a session on the WTO reforms, the systemic issues, challenges that we have been experiencing since the formation of the WTO, and of course the plurilateral issues around the joint statement of initiatives that these speakers are going to be talking to. You will find that since 1995, since the formation of the WTO, there are quite a number of issues that have been at the center of the inequities that we are experiencing up to today. Systemic issues, systemic challenges that most of us have been raising along the way. So in this session, we are going to hear more from this Ministerial Conference, the kind of focus that we have on these particular issues. And to start the discussions, we have Abhijit, who is an independent researcher and the former head of the Center for WTO Studies in India. So he is going to situate and contextualize the issues around the reforms, particularly focusing on the decision-making process within the WTO, the deliberative function within the WTO, the member-driven nature of the WTO, as well as what we have been witnessing now, the informalization of the WTO, looking at the green room processes and other plurilateral approaches that we are seeing. So I'm giving them a maximum of 15 minutes each for their presentations, and then if you have any questions or any comments that you want to note, please just note them, and we will discuss this at the end when everyone has presented. So thank you, and let me give this opportunity to Das.
Thank you, Chair. Good afternoon, ladies and gentlemen. At the last Ministerial Conference, if we look at the outcome document, then we find that the WTO membership agreed to the following, and I quote, to work towards necessary reform of the WTO, unquote. To do what? To improve all its functions. What are the functions of the WTO? Facilitating the implementation, administration, and operation of the WTO agreements and furthering their objectives, the negotiating function, and administering the dispute settlement understanding. Now, pursuant to this mandate, we have seen over the past 1.5 years about a dozen negotiating proposals on the table, mainly by the developed countries, a few by developing countries as well. And most of these proposals, which are targeting WTO reform, would do very little to reform the system, as we know. Instead, it would deform the system, tilt the system against the interests of the developing countries. And I will just focus on that, starting with the decision-making process. All of us are aware that the WTO follows the tradition of, the long-held tradition of taking decisions by consensus. A narrative is sought to be created that it is this consensus decision-making which is creating the problem, which is creating the logjam at the negotiating table. So can we move away from consensus decision-making? We are also seeing attempts at crafting new concepts such as responsible consensus, which in a way exhorts countries not to stand in the way of some of the coalition of the willing to take forward issues of their interest? What would be the impact for a large number of developing countries? If decision making by consensus is changed or bypassed or short-circuited, I am afraid issues mainly of interest to a handful of countries, particularly the rich and powerful, that would predominate the WTO agenda. It's already doing so, but this problem would get accentuated further. Now, linked with this is another issue called the deliberative function. Let's remind ourselves about the WTO rules at this juncture. Issues that are already part of WTO agreements can of course be raised, discussed, deliberated upon in the various committees. For example, issues around agriculture get deliberated upon, discussed in the Committee on Agriculture. Issues on environment get discussed in the Committee on Trade and Environment. Issues on intellectual property get discussed in TRIPS Council, etc. But bear in mind that these discussions are in respect of monitoring and implementing the existing agreements. There is no bar to discussing these issues. However, under the garb of saying that let's discuss and respond to new challenges, let's make WTO fit for the 21st century, let's allow WTO membership to raise issues, to discuss issues which are not even presently in the WTO rule book. Sounds nice, right? We will make WTO fit for the 21st century. What is the problem in doing this? Very simple answer. If an issue is not part of a WTO agreement as it exists today, there is no bar to discussing it, provided the entire membership agrees to discuss it. A good illustration is in respect of what are called the Singapore issues. These were not part of the WTO family of agreements. So in 1996, there was a ministerial decision to start discussing it. The developed countries or proponents of the deliberative function, they want to start discussions on issues outside the WTO agenda without having a mandate, without a consensus, multilaterally endorsed mandate. And why do they want to do it? They want to use these discussions to promote issues of their interest, to get outcomes, to negotiate outcomes which will be along the lines that they want. What is the further consequence? Negotiating agenda at this juncture is decided by consensus. So obviously it involves give and take between different interests. But if the agenda tomorrow can be decided through the so-called deliberative function, developing countries will never be able to get issues of their interest onto the negotiating agenda because there is no give and take. Linked with this is something called reform by doing. Can WTO members improve, make the working of committees more efficient? Can the WTO membership rise up to the occasion, rise up to the challenge and make improvements on how they decide the agenda of meetings, how they conduct the meetings? An interesting proposal in this aspect has been put on the table by many countries. It sounds very innocuous. The proposal is we will decide the agenda of various meetings based on how recent a particular submission is. A new submission on any issue will be first on the agenda. Old submissions will be discussed later. Sounds very logical, right? But let me give you the implications of this very innocuous, logical sounding proposal. Developing countries are very hard put to make even a single proposal. They will make the proposal gets discussed in one meeting, and then it's put in the cold storage. Because new proposals by other countries will be put on the table, they will be discussed first, and if there are revisions to be made on those new proposals, they will continue to get discussed in future meetings. Developing countries will never manage to even put on the table a proposal, forget revising their proposal. So through this process of deciding which items to prioritize on the agenda of various meetings, issues of interest to developing countries will slowly get relegated to the back burner, will keep on falling behind in the agenda. You can well imagine the deliberative function combined with this reform by doing will weaken the already precarious, fragile leverage which developing countries have. In other words, the system as it exists today will be completely deformed, it will be completely tilted to promote further the interests of the developed countries. It doesn't end over there. All of us know that the WTO is supposed to be a member-driven organization. Now, attempts are being made to make fundamental changes to this through two channels. One is empower the WTO Secretariat further, expand its role. How many of you present here think WTO Secretariat works in the interest of developing countries? Please raise your hands. I see no hands. Very clear. What will be the consequence of further enhancing the role of the Secretariat, further empowering the DG with new functions? It's not difficult to imagine at all. Similarly, attempts are being made to give a formal role to industry lobby groups, under the garb of saying that let's make it a multi-stakeholder platform. Again, that will undermine the ability of countries to withhold their balancing of interest through their domestic processes. That will legitimize the lobbying influence, arm twisting by big business. That will again make fundamental changes to the intergovernmental character of this institution. So in a nutshell, what the reform process might end up doing is making very fundamental changes to the WTO as we know today. It will make very fundamental changes to its decision making. It will make fundamental changes to how agenda of committees are decided. It will make fundamental changes to how new issues can be sneaked into the WTO's discussions and subsequently negotiations undertaken on those new issues. In a nutshell, the developing countries are already on the back foot. They will suffer considerable setback in engaging at the WTO. Instead, what should really be done is developing countries themselves have put a large number of proposals for WTO reform, right from the days of the Doha round or even preceding the Doha round. For example, the 100-odd proposals on implementation issues. They constitute a very good basket for a development-oriented WTO reform. Maybe that is the route which we need to go down the path for, and not engage in or not acquiesce to proposals around reform by doing, deliberative function, expand the role of the Secretariat, multi-stakeholder consultation, or issues, narratives, concepts such as flexible multilateralism or responsible consensus. So I will stop at that, and at the end, I'll be very happy to answer questions. So ladies and gentlemen, thank you for your very kind attention.
Thank you very much, Abhijit, for this, and I'm sure we are taking note of the issues that are being raised And in taking note of these issues, I think we also need to think through how best we can approach some of these issues in terms of the actions that we need to take moving forward. So to continue on this, let me come to Jane. Jane is going to talk about the JSIs, the joint statement initiatives, the plurilaterals that he referred to, and I think if you can take us, through from that process, and then we'll end with thank you. You have the floor. And by the way, Jane is a Professor Emeritus with the Faculty of Law, University of Auckland. Yes, you have the floor.
Thank you, Chair. And thank you for coming. I know everyone is incredibly busy today, and I want to acknowledge my fellow, I call you tradies? No, not really, from Aotearoa, New Zealand. My cousins, yeah. I'm a bit of a veteran in this process, as is Abhijit, and so I want to put the discussion around these plurilaterals in a bit of a context. For those of us who remember the Uruguay round, when the negotiations were taking place to set up the World Trade Organization, it was a very, could we maybe shut the door? It was a very fraught process where there was a lot of very careful balancing that took place under a lot of pressure from the developed countries that had essentially run the General Agreement on Tariffs and Trade, the GATT, up to that time. And when the expansion and the consolidation of that into an actual organization was being discussed, there was an important question about both how to ensure that there was a voice for developing countries in that process, but also how there was a structure that would carry through the concept of consensus decision making, and that would have a constitutional framework which is set out in what we know as the Marrakesh Agreement on the establishment of the World Trade Organization. And that's basically the WTO's constitution. So for those who are international lawyers, you will know that international organizations can only do what their constitution allows them to do. You cannot go making things up and then claiming that they are legitimate activities within that organization. And the old power brokers, when they agreed to the establishment of the WTO, assumed that they would continue to exercise effective power and control over it. At the same time, they wanted to lure in a large number of developing countries, but within the framework of an institution and rules of agreements that essentially they had made. And the three main functions or pillars that were set out in the Marrakesh Agreement were dispute settlement, a kind of surveillance and monitoring function, and negotiations. So those are the three mandated functions in the Marrakesh Agreement. There is also a recognition that this is a multilateral trade organization, which was very significant because there had started to be the development of what we call plurilateral agreements amongst some parties to the GATT, but not all of them. And so if you look at the preamble to the Marrakesh Agreement, it talks about basically consolidating a multilateral approach. And when we look at the kind of agreements it talks about, they're all multilateral agreements except for where there is what we call Annex 4 plurilateral agreements, but which can be adopted exclusively by consensus of the members. That is, all the members of the multilateral organisation have to agree to there being an agreement that is a subgroup of those members. And that was a very carefully negotiated, deliberate position to try to keep the kind of balance that would ensure that those who had less economic power and less leverage at the table had, in theory, a sovereign equality as members of the WTO. Now, that actually didn't quite work out the way that developed countries had anticipated, especially because you had a larger number of developing countries, and some of them quite large developing countries. You might remember the bloc that emerged with Brazil and China and South Africa and Russia, the BRICS, which was a kind of counterpoint to the G7 or G8. And so the intention, especially when China joined, was that that China would obey the rules of the West, and that their markets would become open, and that everything will continue as it had before. Now, that's not what has happened. So what we have seen in the establishment in 2001 of the so-called Doha Development Round was a response to demand in developing countries to balance up the agenda of some of the issues that hadn't got resolved in the Uruguay round and were outstanding issues that needed to be sorted. That was 2001. We're now in 2024. The Doha round is languishing somewhere. The developed countries have essentially declared it's dead, but it's not formally dead. That has been a problem for developed countries who have wanted to not address those issues, but to advance the issues of particular interest to them. And so what we saw in 2017 in Buenos Aires at the Ministerial Conference there was a whole lot of subgroups of WTO members issuing joint ministerial statements on matters of interest to them that foreshadowed that they would negotiate agreements on those issues. But unlike the Doha round, which was mandated by consensus of the membership, there was no mandate to pursue those. In fact, in the case of several of these plurilateral agreements, there was actually mandated alternative advancing of those issues within the WTO and within mandated bodies. So what we had was a kind of parallel negotiating process that was set up by the developed countries who didn't like the way that the negotiating pillar of the WTO was going. And so, fast forward to where we are now, these negotiations have been advancing at different paces, but to the point where several of those have resulted in agreements. And the fundamental question then is, how, if there is no legal place for them in terms of the WTO's constitution, do they get adopted as WTO agreements? And some countries, led in particular by South Africa and India, have said they have no place in the WTO. They have to be done according to the rules. Abhijit referred to the phrase that has emerged under this Director General of reform by doing. which is the opposite to reform by the rules. So you do it, and then you work out how you're going to get it adopted. Let me just talk a wee bit about a couple of things on these plurilaterals. Some of you will hear when those wanting to promote them in the WTO say, oh, but there's lots of precedents for these plurilateral agreements. They don't actually tell you the whole story, which is that there are some agreements among just some WTO members that were either negotiated before the WTO was created and then adopted into the WTO by consensus, or they were negotiated at the end of the Uruguay round as the WTO was being adopted, but were mandated in terms of doing it, the bodies they would do it through, and how they were to be adopted. So neither of those are precedents for what we're seeing now. The only plurilateral that's been adopted since the WTO was created, the Information Technology Agreement, was basically just reducing tariffs in countries' GATT schedules. Very different kind of thing from this, and again, there were rules for doing that were followed. So this is totally unprecedented, the situation that we have now. There are a couple of other important things about these plurilateral agreements, and I'm not going to go into great detail about each of the agreements, but because I think the context is what we're focusing on today. The first is that the significant shift that I think Kinder will talk some more about, away from the way that developing countries' interests were dealt with in the past, which was special and differential treatment. That is, having a different application of the rules to developing countries from developed countries. What we have got now is an approach that has application of the same rules to developing countries, but just giving them a bit more time to implement them. More than that, we have what we sometimes refer to as reverse special and differential treatment, because the rules that are being adopted here are rules that already apply largely in developed countries, so they don't have to do anything to implement them. It's the developing countries that are the ones who have to do a whole lot of things to implement. So it's the reverse of giving special and differential treatment to developing countries. What we're also seeing is a shift in the discourse, and you will have seen it all around the billboards here, about inclusivity. And the argument now moving away from the development agenda of North and South to, oh, there are all sorts of inequalities that we have to deal with, of gender and of small and medium enterprises, and occasionally on the margins, Indigenous peoples. And that agenda about inclusivity is basically taking over and shifting out the North-South arguments. And we're seeing that come through very clearly in a number of the JSIs. The other common feature in the JSIs is that they talk about this concept of transparency, which for some of us who are on the outside is a bit ironic, given that there is absolutely no transparency of what happens in these negotiations. But the transparency is designed to say that foreign commercial interests and foreign states have a right to comment on proposed new laws and regulations that a country is going to adopt, have a right to have those comments considered in the decision-making of sovereign states. So lobbying power across all of these JSIs is a common feature. So the ones that we have had implemented or concluded to date, some of you may have seen an announcement yesterday that a reference paper on the domestic regulation of services has been adopted. Now the SDR, as we call it, ignored existing mandates and bodies to deal with this issue under the General Agreement on Trade and Services. Should have been in the Working Party on Domestic Regulation. They went off and did their own thing. They came back with an agreement that framed around light-handed regulatory bodies, and they sought to pop it into the WTO through countries' trade and services schedules. That is an abuse of the schedules, because the schedules are supposed to be sectoral commitments on particular rules. But what's happened here is they made new rules, not new sectoral commitments. New rules should be adopted through the amendment process in the Marrakesh Agreement. They don't want to do that because they won't have consensus, and so they popped it in through the schedules. That was opposed by India and South Africa formally. There has been an arrangement now to bring that back into the Working Party on Domestic Regulation, but also there are discussions around, hasn't formally been initiated, but discussions around reviewing the use and abuse of schedules to achieve that. The second of the JSIs that's underway is on electronic commerce. Now, of course, in the WTO in 1998, there was a work program on electronic commerce that was launched. That has been renewed at basically each ministerial. It's still going. It's meant to take place in the Council on Trade and Services, Council on Trade and Goods, Intellectual Property Rights Council, Committee for Trade and Development. All of that's been set aside in another of these subgroups of negotiations. Long story short on that, it was complicated because you have different interests. You had the US, you had the EU, you have China, you have Nigeria and Cote d'Ivoire, quite different interests there. And they were slowly moving along until the US lobbed a grenade into the negotiations late last year when its very aggressive rules over rights over data, source codes and algorithms, it withdrew from the table. And rather than say, oh dear, okay, we're not going to be able to sort this, they have developed what I refer to as e-commerce light. So a first tranche that is seen to be the less offensive, low-hanging fruit, but which has really serious problems in it because there are no development flexibilities in there except for very tight time frames for the adoption of the rules. And we don't know now where it's going to go. There was a new text that was released on the 21st. I have an analysis of it if anyone wants it. But it's worrying that the structure that they've put in place has very limited protections in it for countries, has no development mechanisms in it at all, and if there is a comprehensive agreement that's adopted on that, those are unlikely to be reopened. The final one is the investment facilitation, sometimes misleadingly referred to as investment facilitation for development. There is no development in the investment facilitation agreement. It is basically another of those agreements that codifies the practices in developed countries, will put quite onerous obligations on developing countries, but also constrain their ability to do things such as apply national interest tests in the vetting of foreign investments, constraints on fees, allowing foreign investors lobbying powers and so on. And so It also has no development dimension. And what we have is, in the next 24 hours, 36 hours, enormous pressure that will come on the membership here to adopt this agreement as a plurilateral agreement under what was called Annex 4 of the Marrakesh Agreement. It can only be done exclusively by consensus of the members. There is no consensus of the members. It has not been put formally on the agenda of this meeting. It is going to be snuck in somewhere, somehow. We don't yet know how. There is no transparency as to how they are going to do that. It is incredibly dangerous as a precedent, not just because of the practices that we're going to see, but because investment is explicitly excluded from the WTO's negotiating agenda since the Doha round, since the July 2004 package, and this is a major, major issue. So if this is not stopped, then anything can happen anytime in the WTO. There will be no rules. There is huge bullying happening. Usually we talk about the bullying being by the US and the EU or Japan, and that still happens. In this case, on this agreement, it's China. And so we really are having terrible power politics driving this. At the same time, the countries that have been objecting, again, led by India and South Africa, have been vilified, most recently in the General Council meeting, where the Director General utterly exceeded her mandated role as an international public servant who was meant to be neutral, and launched an attack on South Africa and India as acting contrary to the interests of developing countries in this agreement. And we can see an attempt will take place to marginalise again India and South Africa over the next 24, 36 hours. So that's basically the situation with the JSIs, why they're incredibly important, not just in their own substantive content, but systemically in what will happen with the WTO.
Thank you, Jane, for this. And I think you can see the movement from the multilateral approach to the JSIs as so many countries are being constricted in terms of the policy space they have, particularly developing countries. And I think these are the issues that we need to be looking at in terms of how we can craft approaches to counter some of these challenges. For example, if you look at earlier on, Jane talked about the BRICS, Brazil, Russia, India, China, South Africa, they are in the same grouping, but when it comes to JSIs, like the investment facilitation one, China is on the other hand, and India and South Africa, they are on the other side. So all these, they are giving us the kind of politics that is behind all these agreements and how we should actually be approaching our interventions. Now, let me move on to Kinder. Kinder, from the issues that have been raised by Das and Jane, she's now going to look at broadly development issues within the WTO, but also talk to issues of reforms linked to the dispute settlement system, to link it to development issues as well, and update us on what is the situation with regards to this MC13. And Kinder, let me give you this.
Thank you. Thanks everyone for being here. My name is Kelsey. I work for the WorldNetwork office in Geneva. Yeah, thanks. And it's ambitious to say that I will talk about dispute settlement. I think dispute settlement is one of the biggest negotiation mandates on the table today. So but I'm happy to answer any questions on this issue, but let me focus on, development given the time limitations. So, as you know, the issue of development and the promise to deliver for development and developing countries is long-standing at the WTO. But every time, every ministerial, we walk out with the disappointment of failure to basically achieve any value added in this regard. If we want to look at development and the system as a whole, we can see that the notion of development has been core to the original design of the system as reflected in the Marrakesh Agreement, which is the mother agreement of the WTO. And there in its preamble, there is the promise that the membership as a whole will undertake positive efforts designed to ensure that developing countries and LDCs secure a share in the growth in international trade commensurate with the needs of the economic development. This is the original objective that the mandates of the WTO and the negotiations of the WTO, including till today, ought to aim to deliver on. And this has been an enabler of setting in place the WTO. Because without this promise being captured under the mother agreement, we potentially might not have had the WTO set in place back then. And coming out from this promise, there was the design of the special and differential treatment provisions under the different agreements of the WTO, which were supposed to allow for developing countries and LDCs to have a differentiated treatment under the rules, not only additional time to implement the same obligations as the developed countries. But also with time, there was the recognition, after the implementation started under the WTO rules, that these special and differential treatment provisions are not operational in a way that adds value for developing countries due to deficiencies in their original design. Also, what was recognized as we had more developing countries come into the system and join the WTO, accede to the WTO, that there are implementation issues that Abhijit had noted. These implementation issues basically are the challenges the developing countries and LDCs have in implementation of the rules that were designed while they were not party to the negotiations or were not sitting around the negotiation table during the original round. So when we talk about delivering on development, from a developing country point of view, there has always been the request to revisit special and differential treatment provisions in order to make them operational so that they can create value for developing countries and LDCs, and to revisit the implementation issues, which means review other rules under the different agreements that hinder the developmental trajectories of developing countries and LDCs. These were reflected in negotiation mandates, both in Doha and in other negotiation mandates coming out of other ministerials. What we are witnessing today in a context, I think we can easily describe it as an assault on all of this. On the original promise, on special and differential treatment, on the whole notion of development. And you can see this assault happening with different tools. One is the attempt to dilute special and differential treatment. So instead of revisiting it and strengthening it, there are countries that are trying to limit the notion of special and differential treatment to mere transition periods. So you get a few more years, 5 to 7 years, and then you get a bit of promises, no guarantees for assistance, which is mere, technical assistance, sending an expert to your capital to support your ministry, relevant ministries, rather than real assistance in terms of financial support and addressing the substance of special and differential treatment. The other assault is through this attempt to differentiate between countries. So now, under the current practice, countries can self-determine whether they are in the category of developing countries according to the UN rules. This is the practice adopted under the WTO, and based on which they would access these flexibilities. What is being attempted is to basically break away from the system and to try to start chipping away and say, okay, the emerging economies do not have the right to identify as developing countries, and thus do not have the right, and thus we can challenge their right to access these special and differential treatment. The other interesting development in this assault is the claim that is emerging from some developed countries to say that development and the issues of policy space is an issue of concern to all of us. So it's not an issue only for developing countries and NDCs. So when we're talking about flexibilities, under the current rules, we all want these flexibilities. So the developed countries as well want the flexibilities, for example, under the subsidies agreement, so that they can throw money as much as they can at their domestic actors, economic players, and basically crowd out, not only break away the ladder for development and catch up by developing countries, but basically wipe out any opportunities for delivering on the original mandate that I recited, which is ensuring that developing countries secure a share in the international trade commensurate with their development needs. So this we need to note that this is happening. We might not be seeing it in an explicit way, but this is happening every day in every meeting of the WTO on all the issues. So now, in the context of this ministerial, the developing countries, including the African group and other developing countries, have been asking for specific elements. They want the mandate on strengthening the special and differential treatment to be reaffirmed. They even came down with their ambition. Just reaffirm the mandate so we can continue working on it in the future. This reaffirmation now is nowhere to be found, and the paragraph that they proposed on this issue to be reflected in the ministerial declaration have been put in an annex that now, you know, some are arguing that, we don't have enough time to deal with the annex, we just deal with the core text of the ministerial declaration. So there's a potential that even the reaffirmation of this mandate will not happen. The other ask was the ask to examine the effect of WTO agreements on the ability of developing countries to industrialize, to diversify their economies, and to transform structurally their economies in order to address development. So this is a notion that the African group have developed through multiple submissions over the last 2 years. The African group has been, and the African member states have been very diligent in developing and arguing substantively and legally this issue. They are calling for policy space for industrial development, and they want a mandate to be agreed in the ministerial meeting and reflected in the ministerial declaration to this effect. The response to that was, you know, this issue of industrial development and policy space is an issue for all of us, including us, developed countries, and the European Union basically wants to claim that this is also the agenda of the European Union, and they want to bundle this ask by the developing countries and the African group together with an ask by the European Union to basically work on new rules on industrial subsidies, which is their interest. So they are trying to combine these two agendas and the language on these two issues in the ministerial outcome document, which would effectively, this issue would effectively do is it would relay or sideline the concern of the African group and the ask of the African group, and it will bundle it with something that they do not agree to. So there is this trade-off that is attempted, and there is this also attempt to claim that there is agreement that these two issues come together in the ministerial outcome document, but we know from all what we hear from the developing countries that they want their issues to be addressed separately, because their issues emerge from or are rooted in the implementation challenge that Abhijit does have spoken about. This call to revisit how the WTO rules affect their ability to industrialize and achieve structural transformation in the economy is rooted in the original request they had to review the rules in order to address their implementation challenge. It has nothing to do with the request from some of the developed countries today to add new rules to the WTO in order to limit the ability of countries to use industrial subsidies as a tool for development. So these are some of the background games or the maneuvers in order also to appropriate notions that have been central to the concern of developing countries and LDCs under the WTO and dilute them in that way. And I see that part of basically the assault on the asks and the development concerns of the developing countries at the WTO. The other issue that was requested by developing countries, particularly by Pakistan, supported by other developing countries, is to have an inbuilt mechanism in the WTO to allow developing countries and LDCs to better and more expeditiously respond to crises they face, especially when these crises are triggered by exogenous factors such as climatic, food, health, financial and economic crises, so as to avoid deepening and spreading of such crises. The response to them was, well, we are all facing issues with resilience and response to the crisis, so this is an issue for all of us. So this is why you can see under the ministerial outcome declaration now, in the core text, paragraph 22 talks about recognizing the short-term challenges faced by members, so all members, in particular developing countries confronting global and domestic crises. So the notion was extrapolated to cover all members rather than to address the concerns of developing countries and LDCs. So these are the specifics that are being debated today. Actually, the working session on the ministerial declaration is now. For sure, there are multiple other asks, such as issues pertaining to technology transfer and debt, but what I talked about are basically the three core elements that were requested by developing countries. To close, I would say, just to link back to what Professor Abhijit and Professor Kelsey have talked about, that the strengthening the WTO as a multilateral forum is intrinsically linked to the ability of developing of the WTO to deliver on the development issues of developing countries. Because the moment we fragment the system and we allow power dynamics to overtake the agenda setting at the WTO and dilute the leverages that the different countries at different levels of development and with different sizes of economies have over determining the agenda and being able to get something out of this agenda, then we have lost the ability of delivering anything for development, because then the big players, the big economies will basically be determining the agenda, will be determining what issues get addressed, what harvest is done at these ministerials, and the concerns of developing countries and the development concerns get relayed to the future, as has been mostly the case in the history of the WTO thus far.
Thank you, Kinda, for the elaborate presentation of the development aspects within the WTO. So, indeed, there is an assumption within the WTO that by negotiating these rules, all countries are at the same level of development. And therefore, in terms of implementation, all countries must implement these rules. And to achieve development, as Peter was saying, there is an assumption also that because all countries are at the same level of development and therefore we all require development, there is no recognition of the role that some of these countries played in the history of the development or underdevelopment of some of the members of the WTO. And I think these are some of the issues that we need to emphasize. I wish if Walter Rodney was still alive today to write another book, on how some of the countries played a role in the status that they are in today. So, colleagues, here we are. The issues are on the table. The reform issues, the development issues, the plurilaterals, and these issues are not isolated. They are all linked together. If we are to achieve development, then the rules must be looked at from an institutional perspective, but they also must be looked at from a process perspective, and also they must be looked at from an outcome perspective. So, because we have all these issues, I know you have been taking notes and you have questions, you have comments to make. We have about 20 minutes for discussions, and let me just open this up for any inputs. I recognize you as our first. Yes, you can go ahead.
Just speak up. Yeah, thank you so much. Well, plenty of you know me. My name is Maestros. I work for a Dutch NGO called Both Ends. And so I'm regularly in conversations with our Dutch delegation, and I've tabled this issue about the joint statement initiatives. And what I would what I would really love is if you could help me find some counter arguments to what I've been hearing from them. Like for example, and so when it comes to the joint statement initiatives, if you disregard the principle that the WTO is founded on multilateralism, I mean that's the principal argument. But they would say, well, yes, but then we have so many members now that anybody can block any progress. And basically, the two things that I've been hearing from them is one, hey, but we don't force anybody to join these initiatives. So, I mean, we can just form our group and do our thing, but we're not forcing anybody to join, so what's the problem? And then second, what I've been hearing is, well, there's also developing countries among the signatories, so what you're saying is false about that it puts developing countries at a disadvantage. And I would love to hear what you would respond to these arguments, and then I can take it on board whenever I speak to them the next time. Thanks.
Thank you. Thank you for that. Yes, Madam, let me recognize you.
Yes, thank you very much. My name is Hilda Hinai. I'm Secretary General of the Arab Swiss Chamber of Commerce and Industry in Geneva. I was a WTO negotiator for Oman for 22 years before joining the chamber. My question, I've been listening to all our esteemed speakers who I know very well, but my question is, after listening to all of you, I've been taking notes, by the way, because now I don't attend the WTO meetings, but after listening, I can see that from the days when I was in the WTO to now, that the positions of the developing countries are deteriorating, they're not becoming stronger. And from what I hear from my friends and colleagues who are still attending the WTO negotiations, they tell me that the negotiators' positions are not as strong as it used to be in the old days when I was still in the WTO. Do you think the positions are not strong because people do not have enough expertise to deal with the files and technical capabilities and skills? Or is it because developing countries, economic transformation is happening, so they are changing their positions? Or is it because there is a lot of pressure on them and they cannot resist it politically and they are becoming weaker? Thank you.
Thank you very much for that important question. I saw a hand first here and then I'll come back to you.
My name is Anil Sharma. I am from India, Sudeshi Jagannat. So, as a desperate civil society member, my question is, like if there is a dispute between the members, they go to dispute resolution. Do, as a civil society, we have any forum where we can argue that this provision has been made which is ultra vires? And similarly, is there any provision where we can raise the issue of impeachment of DG? So these questions.
Thank you, Alfred.
Thank you, Chair. Alfred from WTO. I have a question for Professor Jen. When you look at the IFD and link it to BITs, and again in the mode of international investment agreement reforms, where some countries, and let me speak to African countries in particular, which are revising their investment codes to strike out some of the aspects that take away their, change their process space, but also some which are terminating BITs. What is the linkage between the IFD and the erosion of the policy space that the countries fighting so hard to have when it comes to bilateral investment engagement processes? Thank you.
Okay, can I just take, can I see the hands now? How many? Okay, so I'll take this last two. I'll start with you.
Hi, my name is Vikram Naik. Great to be here. I'm from India. I work with the law firm there. Just a question. I think the debate and something that you added, it's more of a subjective standard. Would your research or foray into the subject be indicative of an objective standard to possibly assess and present that there is a deterioration in negotiating positions or standards for developing countries? Because the debate is from a subjective basis at all times. If there are any factors that can be put together to objectively assess that developing or LDC goals or positions are objectively deteriorating through these parameters, which would rather justify the opposition instead of it being fragmented or stakeholder driven. But if there's any indication of something to evolve a standard or an objective standard, assessing developing parameters or development parameters that are relevant.
Okay, thank you. Yes.
Kia ora, Jason Mika, Professor of Management at Waikato University. Very pleased to hear the audio from the panel. My question is basically, what's the problem? What is holding the WTO back from delivering on its promise of trade to benefit developing countries? What's the holdup? And then related to that is, well, what's the solution? What could the WTO do to deliver on its promise for trade to benefit developing countries?
Okay, thank you, colleagues, for the questions and the comments. Let me go back to my panel, and let me start with you, Das. Yes.
Thank you, Chair, and thank you, participants, for asking very piercing questions. Madam, you mentioned the point about the position of developing countries weakening. I completely agree with you. I also agree with some parts of the diagnosis that you have put forward. Let me also add a few other reasons for it. An important reason is, and that links with WTO reform proposals, is an increasing tendency towards informalization of the negotiating process. That is something which we have seen in the context of WTO reform negotiations. We had a chair of the informal process. Chair was foisted on the countries who wanted to engage in the reform process. The chair was foisted by a particular member, which said, I will not engage if this chair is not agreed. No minutes were kept. We don't know who made what proposals. We don't know in the consolidated text whose interests are what. So how do we assess where does the balance of interests lie in these negotiations? This is not just one instance. Other instances of informalization of the negotiating process is the increased use of so-called thematic sessions, deliberative sessions. Who decides these sessions? Who decides the speakers? Absolutely the WTO Secretariat. And all these issues are sought to be given legal standing through the reform process. So that certainly is one reason why the negotiating positions of developing countries have weakened. Another reason is the success of divide and rule strategy. And the negotiating text on fisheries subsidies is a brilliant example of how that strategy has really succeeded. Hand out small crumbs to developing countries who don't pose a competitive challenge to the larger players, so that they have no incentive to coalesce around bigger developing countries, and thereafter pick each individual developing country and, within quotes, handle them separately. The third reason is developing countries themselves cannot be absolved of the blame, at least in some measure. They have to realize that if they don't hang together, they will hang separately. And I'm afraid the latter reality of hanging separately, we are already witnessing that. And that, to my mind, is a very, very sad reality. Earlier, the developing countries realized that what they achieved in 2003 through the G20 coalition in agriculture, it will be better for them to, it will be a useful reminder for them that, hey, in this game of power dynamics, asymmetric relations, coalition is the only way to protect our interests. Anil Sharma-ji, I'll leave that question for Jane and Kinda to address. I have no idea whether the DG can be impeached and how. But the point remains that when if she stands for re-election, then countries must take a very careful call on how an international civil servant is expected to conduct herself or himself, and whether the DG met those standards. Vikram, is there any objective measure? Offhand, I can't think of any. But what I can think of is that even when developing countries, even in the time of COVID, when it was really a matter of life and death, even when more than 100 countries joined hands together, even when the Pope talked of problems regarding access to medicine because of intellectual property right. Even when Hollywood stars, who may have nothing to do with international trade, even when they championed the TRIPS waiver, even when former prime ministers and presidents of developed countries championed the TRIPS waiver, just 3 or 4 developed countries dug in their heels and decided to bend in favor of patents rather than patients. It just shows where the problem in the system lies. And Jason, the problem in the system is just one. The WTO rules as they exist today and as they are sought to be crafted for tomorrow will achieve just 2 things. Number 1, preserving the first mover advantage of commercially successful players in the developed world. And number 2, tying the hands of developing countries from pursuing catch-up policies. This is what has to change. Developed countries won't change it for us. The power lies in the hands of developing countries, the ability lies in the hands of developing countries to change this fundamental approach to WTO negotiations. Fisheries negotiations is a prime example. Those countries who have large industrial fishing fleets built on the back of millions or hundreds of millions of state support, they can continue to provide subsidies, whereas those who do not have large industrial fishing fleets, you cannot now create an industrial fishing fleet. Net result? Those who have the ability to fish in high seas, they will continue to do so. Those who do not have the ability today are forbidden from doing it forever. That is the template of WTO rules, and that is what has to be changed. The solution really is for the developing countries to realize how these rules are compromising their ability to follow their aspirations for a development-oriented policy. Once they realize it and once they decide that, yes, there may be heterogeneity in interest among developing countries, but the commonality in their interest is much more than commonality of their interest with those of the developed world. There could be commonalities, yes, but the commonalities among developing countries is much more. This is something which developing countries unfortunately have forgotten. I have spoken enough, I'm going to stop at that. Thank you.
Thank you, Das, for this. I will be forgiven for saying this, not as chair of this meeting, but as a participant, that developing countries are victims of their own analytical strengths. We have managed to identify the challenges that are limiting the participation of developing countries in this multilateral process, and because of that, by exposing those, the other countries have taken advantage of that and they are utilizing that. The issues of the thematic sessions, he's talking about the plurilaterals, the issues that we have raised about capacities that we have in Geneva and so forth, they're the ones that are being capitalized on by other countries. And this is exactly what is happening. So, yeah, it's a hard fight that we are in. Now, between the two of you, who wants to go next? Oh, okay. So, Jane, you can go next.
Let me try not to repeat what Abhijit has said. To deal with the arguments in defence of the JSIs, I mean, I always find it ironic that they talk about the blocking of consensus as being a South issue, and in particular targeting South Africa and India, when what happened to the Doha round? Yeah? Who in fact has blocked the development parts of the agenda that they don't want, and then blame those who actually say let's play by the rules when the powerful have gone up to do their own thing. About this notion of open plurilateralism. Right? Anyone can join. Yeah? Well, firstly, who sets the agenda? But I work a lot with Pacific Island countries. Some of them don't even have a Geneva office. They work out from Brussels, if they're lucky. They try to go to the main council meetings. How do they go to a proliferation of plurilateral meetings where their ability to, okay, we're being told that we have to wind up because there's people outside, when they can't, how can they be equal players in this process? I could tell you hair-raising stories about why some of the countries have signed on to these things, and they are shameful. The question of ultra vires, how do we challenge them if they gavel it through illegally? There is actually nothing you can do. There is no formal mechanism. And this is a really major dilemma. I'm happy to talk about the bits issue, Africa, and there's really important overlaps there. And I would say as well that one of the reasons why China is so active in this is the Belt and Road, the overlap with the Belt and Road. So it's not just the bilateral investment treaties, it's the Belt and Road as well.
Okay, just half a minute, because we're still at 29, yeah. Just on the issue of... Yeah, just quickly, just on the issue of that we're not forcing anyone to join the plurilaterals. Just to recall that the nature of the WTO, as it has been designed, it is designed to advance an integrated multilateral trading system. The difference between this and what existed before, which is the GATT, is that under the WTO, all members have a collective role in a multilateral oversight on how the agenda is expanded, so what rules get covered under the WTO agreement and how they get covered. So the idea that we can negotiate anything outside the WTO without a mandate, and then we only need to have consensus on bringing it into the WTO is not accurate, because this defies the original objective. This approach would allow the WTO to become a platform, or to re-become, like the GATT was, a platform for deals and contracts among a group of countries who are interested. What we need to make sure we respond to such kind of claims is that both the expansion of the issues that get covered under the WTO, so deciding on whether investment should come under the WTO umbrella, needs to be decided by consensus, and how it comes into the WTO, whether as a multilateral agreement or a plurilateral agreement, also needs to be decided by consensus. These are two elements that are part and parcel of the system.
Okay, thank you very much for this. People must remember that we also started 10 minutes late. We were waiting outside, and we also wanted to utilize this time. But thank you so much, colleagues, for the presentations and also for the inputs from the floor. So let us continue to engage on this issue. Thank you.